very much. Hello again after the break. I see we're now 30 or 28. We talked so far about the general institutes of gender competent criminal law, and we talked about actually the very small amount of possible loopholes, so to say, where the issue of gender could basically enter such a basically very closed system as criminal law is. Now let's switch to the special part of criminal law, and basically when we talk about crimes against women, we in the end talk always about violence, one or the other. And I've said it before, you can see that already in the definition and the scope of the Istanbul Convention, and in many aspects of it. It starts with Article 1 regarding the purposes of the convention. I will just mention it briefly. I will not talk too much of it, but just for you to know that how is it recognized. The purpose, the goal of the convention is to protect women against all forms of violence and prevent, prosecute and eliminate violence against women and domestic violence. It's also, the goal is also The goal is also to contribute to the elimination of all forms of discrimination against women and promote substantial equality between women and men. So this is the goal in the aftermath, so to say. So prevention, prosecution, elimination, protection. The scope of the convention is the same. It should apply to all forms of violence against women, including domestic violence, which affects women disproportionately. Parties are encouraged to apply this convention to all victims of domestic violence, and they shall pay particular attention to women as victims of gender-based violence in implementing the provisions of this convention. And here we have a certain paradoxon, where in the judicial practice of Serbia, but not only in Serbia, we have a really, really high amount of reports, charges and convictions for domestic violence. So it has become some kind of trend, let's say 10 years ago, when the public attention has shifted towards domestic violence. In other words, the issue of women or the protection of women as such is not addressed in a direct manner in terms that women are seen, regarded as victims, but more indirectly through the issue of domestic violence. Whereby we have to say, when it comes to domestic violence, the victim of domestic violence is, again, not the individual person, but the family as such. And the individuals that are affected by this crime are seen only as part of the family. So the attack goes against the family, not against the individuals, and especially not against wives, daughters, etc. They are not even explicitly mentioned. The issue of domestic violence, at least in Serbian law, goes even further than that, and it can include emotional and sexual partners with which you have not shared a common household. So in other relation, in relation to who is considered to be a member of the family, again, family, it goes beyond something that we are used to so far in this definition. Back to violence. The Istanbul Convention defines violence as well. It's the intentional use of physical force or power, threatened or actual, against oneself, another person, or against a group or community that either results in or has a high likelihood of resulting in injury, death, psychological harm, maldevelopment, deprivation. This is a definition of the World Health Organization, but however, it is the basic definition of violence when it comes to the UN and other international documents as well, including the Istanbul Convention. So the point is, it has to be intentional use, no negligence. It has to be actual, so violence that actually happened, or only threat of violence, this would suffice. and there should be a high likelihood of injury, death, psychological harm, maldevelopment, or deprivation. And if you look at those possible results, they are very various, they're very vague and not of the same intention. Death is not the same as maldevelopment or deprivation. So the issue or the notion of violence as such is very broad. With this we come to the types of violence which are regarded in general: physical and sexual violence, emotional, economic, and neglect or deprivation. When we think about violence, especially when non-lawyers think about violence, they usually think about physical violence, to a lesser extent about sexual violence. Almost nobody thinks of emotional violence, and economic violence is something that has risen to attention only in the last few years. Neglect or deprivation is something that's definitely at the end of the scale when it comes to violence. Again, if you look at the setting of where violence can happen and what violence can be, there are different areas. You have the private life, you have work, you have the broader community, and you have the public space. And each and every one of them, violence can happen. Violence as such can manifest itself in various forms. It starts from some kind of online harassment that seems to be far away, not even maybe threatening, up to rape, slavery, trafficking in human beings. So in other words, the scope and the settings of violence are very broad. And I haven't mentioned this before, but when it comes again to the Istanbul Convention, they are very particular about that they cover not only violence in public space, but also violence in private space. And this is one of the areas that are where criminal law gets into when we talk about private relationships between people. We have to evaluate very much to what extent do we want to interact with our basically state power. The Istanbul Convention defines many various forms of violence. First of all, it defines violence against women as a violation of human rights and a form of discrimination against women, and shall mean all acts of gender-based violence that result in or are likely to result in. So a kind of relativization of physical, sexual, psychological, or economic harm or suffering to women, including threats of such acts, coercion, or arbitrary deprivation of liberty, whether occurring in public or in private life. This is what I have mentioned before. So what's laudable here is that it also includes economic harm, which was not done in other international documents. Although the Istanbul Convention is basically a regional document, it applies only to the states of the Council of Europe, it has reached an international public and is recognizable as such. And today, if you say Istanbul Convention, each and every one of us, also in other parts of the world, know what we talk about. And this is also the reason why, for example, after the withdrawal of Turkey, there were protests in the streets of Istanbul, but not only there, to protest against this withdrawal. And then we also have a definition of domestic violence as all acts of physical, sexual, psychological, or economic violence that occur within the family or domestic unit or between former or current spouses or partners, whether or not the perpetrator shares or has shared the same residence with the victim. This is what I've mentioned when I talked about the domestic violence cases in Serbia. Here we have some kind of expanding or broadening the scope of what domestic means, in terms of it's not only a family unit, but it's also a domestic unit, first of all. And secondly, it does not only have to be the current spouses, it includes also current spouses, but also partners that were not formally, officially together. And those people, it's enough if they have only shared an emotional sexual relationship. They do not have to have shared the same residence with the victim. So the scope of domestic violence as such is very, very broad defined. This goes along with, let's say, a new attitude of relationship between people, because you do not have to be married to be with someone anymore. And this is something that the law and international documents recognize very, very well. Then we have also the definition of gender-based violence, that is violence directed against a woman because she is a woman or that affects women disproportionate. And this is basically what we talk about. When we talk about women, this also includes girls under the age of 18. Also, we mentioned violence when it comes to fundamental rights, equality, and non-discrimination. It's the right for everyone, particularly women, to live free from violence in both the public and the private sphere. So once again, both spheres are underlined. Again, inclusion of economic violence, and again mentioning the culture, custom, religion, tradition, and so-called honor cannot be used as justification for violence against women. So on very much spots in the Istanbul Convention, it was repeated what violence is, what is allowed, and what it's not. So they were very keen about putting a fundament, a basis of this issue. Now, when it comes to particular offenses, I talked to Anna before, and I was before said to look a bit more into female genital mutilation, so I did. So sorry if you will heard something that you already heard, but I think it's a highly interesting question. It's very gender-related, maybe the most gender-related issue that there is currently. But beside that, I just wanted to show you briefly about some other forms of violence. There are more. There are 8 criminal offenses in the Istanbul Convention that are being underlined, but out of those 8, I wanted to stress psychological and physical violence and sexual violence, which includes rape and sexual harassment, just briefly. Now, when it comes to psychological violence, we have one particular Article 33, and it's about the intentional conduct of seriously impairing a person's psychological integrity through coercion or threats. And this is to be criminalized. It can be a criminal offense or any other form of criminal behavior. What is important, again, it has to be intentional. It has to have a serious impact of a person's psychological integrity through coercion or threats. So also here, threats would be enough to criminalize such behavior, and this goes along with many criminal regulations. Physical violence is the intentional conduct of committing acts of physical violence, basically the same as before, just another form of violence. Then Article 36, sexual violence, including rape. Again, intentional conducts are criminalized. Engaging in non-consensual vaginal, anal, or oral penetration of a sexual nature of the body of another person with any bodily part or object. Engaging in other non-consensual acts of a sexual nature with a person. Not harassment, but other forms of sexual violence. Causing another person to engage in non-consensual acts, basically complicity. And what is very important here, and also not usual for an international document, really, is that they tackle the issue of consent. The issue of consent is something that has been overlooked even in the dogmatics of criminal law. Only recently we have started to talk about it, although it basically means if consent exists, this means that what has been done as such is not criminally valid anymore. For example, it can exclude typicity, the second element of crime, or unlawfulness, the third element of crime. And here it is stated that consent must be given voluntarily as the result of the person's free will, assessed in the context of the surrounding circumstances. Now, this is relatively broad. What is important for us to know is that it has to be given this consent voluntarily, so that if there is any pressure, any threat, this means that there is no consent in a legally valid way. And our basically starting point is that the people have the free will to give consent. So this means that the people should have the power to have the power over the legal good they intend to consent to, for example, for an injury. And also they should be very well aware of the fact what they are doing and to understand what they are doing. So what is expected of them, what consent means, and what they consent to if they say yes to the certain behavior. Again, here we talk about legislative or other measures, and it goes against acts of former or current spouses or partners as recognized by internal law. So again, not only current but also former spouses. And in this regard, when it comes to rape, there is the case of MC versus Bulgaria, very important, from 2003. And it's said that any rigid approach to the prosecution of sexual offenses, such as requiring proof of physical resistance in all circumstances, risks leaving certain types of rape unpunished. In other words, there should not be any direct proof of physical resistance in order to say that one person was raped, because it risks, as it said here, to leave certain types of rape that have been done only, for example, by threatening, without any physical or not much physical strength, to be left outside of the criminal scope. It jeopardizes the effective protection of the individual's sexual autonomy. So the mere fact of whether the woman has to show resistance or not has changed. Regardless of the specific wording chosen by the legislator, in a number of countries, the prosecution of non-consensual sexual acts in all circumstances is sought and practiced by means of interpretation of the relevant statutory terms and through a context-sensitive assessment of the evidence. What does that mean? It means that we cannot say it in a general way when consent is given or not. It means that we have to look at the specific case and to assess the existence or non-existence of resistance, and by this also the consent regarding this case. When it comes to MC versus Bulgaria, the perpetrators, the woman was accused of not sufficiently showing resistance to her perpetrators, and that was the problem of this particular case. In Article 40, there's also, in addition to rape, basically, it goes together as sexual violence. It's about sexual harassment, and those are any forms of unwanted verbal, non-verbal, or physical conducts of a sexual nature with the purpose or effect of violating the dignity of a person, in particular when creating an intimidating, hostile, degrading, humiliating, or offensive environment. So it can be verbal, but also non-verbal, which means that the physical contact, or this, what is regarded as violence of a sexual nature, because also sexual harassment comes under the terms of violence, does not have to be conducted in a direct physical manner. It's enough if you say something to somebody which he or she understands as intimidating, hostile, degrading, humiliating, or offensive. So in other words, the scope of what is to be understood as sexually not acceptable is broadened by this definition. At the same time, sexual harassment is the form of sexual violence which has the most socially acceptable forms. Again, when we talk about criminal law, we have something that is called social adequacy, which means that, for example, from criminal law, if you give a small gift to some person, it's not like you're already bribing him. It's something that is socially acceptable to give some gifts. The same here. If you give a compliment to a woman, it's not always to be treated as sexual harassment. And when we introduced in 2016 this particular offense into Serbian criminal code, there was a huge outcry on whether now every compliment that was given to a woman could be regarded as sexual harassment. Of course it didn't in practice. Now we come to our main criminal offense here for today. It's female genital mutilation. It's regulated in Article 38, and now I will turn a bit down the speed. Parties shall take the necessary legislative or other measures to ensure that the following intentional conducts are criminalized. So again, intention, which is something that is logic for this kind of crime. It's about excising, infibulating, or performing any other mutilation to the whole or any part of a woman's labia majora, labia minora, or clitoris, coercing or procuring a woman to undergo any of the acts listed in point A, and inciting, coercing, or procuring a girl to undergo any of the acts listed in point A. What is good here in this regulation, again, forms of complicity are included as well. This is something that goes a bit under the radar, but here it is very specifically stated. Now, about female genital mutilation, here we again have, as with the case of violence, a definition of the World Health Organization, which again is recognized worldwide. Female genital mutilation are all procedures that involve partial or total removal of the external female genitalia or other injury to the female organs for non-medical purposes. So what's important here is that it's an injury and it's done for non-medical purposes. Those two things have to be underlined: injury, non-medical purposes. It is to be more specific about that, the irreversible, invasive alteration of female genitalia with absolutely no medical indication nor use, but with a long list of short-term and long-term physical damages and psychological traumas. Now, here again to underline, irreversible, invasive alteration of female genitalia without any medical indication. If you have medical procedures and if you want to exclude unlawfulness from medical procedures, one of the conditions for that is the existence of medical indications. Here you do not have it, nor any other use. On the other side, you have a whole list, it's literally a list of short-term and long-term physical damages and psychological traumas. Now, what's here important to annotate is it starts with the terminology. Because the term female genital mutilation, as it's, for example, you can find it in the Serbian criminal code, you will not find everywhere. And when you read an article or listen to somebody who talks about that, already when you hear about what words he or she uses, you can be sure about his or her attitude towards this issue. Because alternative terms for FGM are female genital cutting and female genital circumcision. Those are the alternative terms. Why are those terms proposed? They are proposed as ways of signaling cultural sensitivity for communities that practice FGM. So they very on purpose do not want to name it as it is, mutilation, but they call it cutting or circumcision. Now, while the use of adapted language is as such recommended when it comes to prevention and direct victim support, it's okay that you talk to the victim in a very sensitive way. However, these two terms, cutting and circumcision, do not fully reflect the nature of this intervention. Even more, they are partly blurring it. Why? Cutting, for example, neither reveals the lack of medical indication nor the scope of the intervention. So, neither the lack of the indication nor the scope of the intervention. When you say cutting, it could be cutting, small cutting of what? Hair of anything. You do not connect that to such an invasive act. Circumcision, which literally means cutting around, is anatomically speaking incorrect, and it is not even the more precise term of excision. I will talk about it in a minute. Grasps all variations of FGM. Furthermore, the term circumcision is more suitable for the genital alterations of boys and men. So people who use the term circumcision do that mostly on purpose because they want to draw a line to male circumcision. Now, what can also be often heard about this issue, we come back to the things I talked before that. Not all crimes, not all gender-related crimes are regarded as such. The interpretations and understandings vary. And here, when it comes to FGM, you also have some relativistic approaches. For example, you can hear the following comments. It's an overreach and imposing Western hegemony on African nations because the majority of the women who are mutilated are from Africa. Or it's also mentioned as a neocolonialism stunt of Western ideology meant to embarrass Africans. It's born out of the West liberal feminism, which is ideologically anti-ethical. And it emphasizes that FGM is a cultural good that prepares women for childbirth pain and teaches African women resilience and strength. Young girls love the procedure and sit stoically during the procedure without flinching to demonstrate maturity and readiness to face the hardships they often encounter. However, so those are the relativistic arguments for this. You're cut, but if you don't show any sign that it hurts you, you're a great woman to become by this.
Ivana,
Mm-hmm.
excuse me.
Mm-hmm.
And just to add to these relativizing approaches, the comments which were going on during the previous lectures and sessions, for example, from one student who tried to equalize circumcision with genital mutilation, in a sense that equally the harm is done to the boys, and that this approach, how to say, gender sensitive, in favor or much more critical towards mutilation, has been a little bit one-sided. So please, if you can comment that as well.
I actually have that on one of my slides, and if
Yes,
I may
know,
just leave it.
Just once again to sum up, among these arguments related to relativization
Yeah.
of the topic consideration, just put this once again.
Okay, I'll step into the right into this. Let me see it, because there are more than I just want to more than one argument. Yes. Okay. Can I put it for later? Because
Yes,
okay, I'll put it for later because I have a scheme I want to
Yes,
because it's more than that. Okay. Now, going back to the terminology, why it's not a cutting, not a circumcision, but it's a mutilation because there is no medical indication for it. It's irreversible and invasive, and for that, it's the most basic definition, basically, of a mutilation. And although this practice is very old, we can now see a very interesting development that right now we have more and more articles that do not want to call it what it is, a mutilation, but they put it either in alternative terms, cutting, or they talk about circumcision, which it is not. Now, I have to say, I thought of before putting this picture, I thought of should I put a picture, but then again, it's something that's happening, and we should really talk about that. And me as a criminal lawyer, I have no fear in this regard. So, what is female genital mutilation? Because people do not grasp the full extent of it. I wanted to show you the 4 basic categories with different degrees of impairment. So what female genital mutilation is. The first type is called clitoridectomy. The second, excision. Type 3 is infibulation, and type 4, it's not here. There are other forms of alteration of the female genitalia. This is a classification in accordance with the FGW, with the World Health Organization definition. And clitoridectomy, type 1 you see, is the partial or total removal of the clitoris, and in very rare cases only the prepuce, like the fold of the skin surrounding the clitoris. Type 2, called excision, involves the partial or total removal of the clitoris and the labia minora, with or without excision of the labia majora. Then type 3, infibulation, is the most severe form of FGM. It is the narrowing of the vaginal opening through the creation of a covering seal. The seal is formed by cutting and repositioning the inner or outer labia with or without removal of the clitoris. The repositioning of the round edges is done by stitching or holding the cut areas together for a certain period of time to create the covering seal, very often by bounding the girl's legs together for up to 40 days. So in general, when it's done, especially in African communities, the woman, the girl, it's mostly done to girls, is taken outside of the community. She is dressed very well and prepared for this very festive event for her in her life when she's basically becoming a woman. She's taken somewhere out of her village. She was cut. I will say more about that in a minute. And then she was very often left alone to bleed out, and very often also buried into sand, for the sand to take up the blood. So in the end, if she survives, good. If not, then not. But this is something that's happening, and this is especially the problem with this 3rd type of infibulation. And what's the problem here, as you may guess? Only a small opening is left for urine and menstrual blood to flow out. So it very often stays within the body of a woman. Then there's type 4, other harmful procedures to the female genitalia for non-medical purposes like pricking, piercing, incising, scraping, etc. Now, what are the consequences to all of this? You may guess. The problem is that the girls and women are usually cut in unsanitary conditions with non-sterilized equipment. like knives, razor blades, scissors, broken glass, needles, and of course without anesthesia, of course. The wound is sewed with crude instruments like thorns, and this indicates the repercussions of the procedure, so you may guess what happens later. The first are the immediate or short-term risks of health complications, severe pain, excessive bleeding, which can lead to shock or death, infections later on with HTV, hepatitis B and C, then injuries to local organs during the cutting, bladder, bowel perforations, etc. FGM of school-age girls can be regarded as a special category, by the way, with consequences ranging from difficulties in walking, sitting, or standing over lengthy absences from classes, etc. Longer-term complications, and this is maybe the bigger problem, are numerous and vary even more. They can consist of gynecological problems, chronic pelvic pain, pelvic inflammatory disease, chronic urinary tract infections, increased risk of late detection of cervical cancer, menstrual disorders, surgical complications, including fistulization with incontinence, adhesions and obstructions, and psychological problems, psychological distress, mental health problems, depression, post-traumatic stress disorder, schizophrenia, somatization, etc., sexual dysfunction. A particular subgroup concerns the complications in pregnancy, if fertility issues don't arise earlier, because many women do actually grasp that they have been mutilated only when they become pregnant and get, usually at the very late stages of their pregnancy, to the doctor. Only then they hear from the doctor that this was done what shouldn't have been done, because the doctor has then to open them up again for the upcoming birth. This list goes on and on. It's literally more than one list, and it illustrates that there are no health benefits whatsoever of this practice, but only physical, psychological, reproductive, and even economic harms that follows this intervention. I mentioned that. Why is this also important? This is the next slide. I just skipped a lot of the consequences because I have three pages of the consequences. Now, regarding the female genital mutilation in the gender context, we can talk here about the gendered nature of the crime. On the one side regarding the actors, and on the other side regarding the reasons or justifications for FGM. When it comes to the actors, the convention itself, the Istanbul Convention, breaks with the principle of gender neutrality due to the nature of female genital mutilation. Because the Istanbul Convention as such, although it talks a lot about women, could also be applied to men. This is something that's often easily forgotten, as I have said. However, when it comes to female genital mutilation, it's clear that there is no gender neutrality. And the name and the content of the offense define that the victims of this crime are necessarily women and girls. Even more, gender-based asylum claims are also explicitly connected to FGM, and female genital mutilation and forced marriage are mentioned first when it comes to gender-related persecutions. So in this regard, FGM is not gender neutral, but it's gender exclusive. It's also not only about the victim, but it's also about the perpetrator as well. This is also a gendered issue, which is often overlooked, because in communities where FGM is practiced, the ritual is supported by both men and women. So the whole community regards this as a practice that should be done, usually without further questioning it. Men, on the other side, are rarely present during the intervention. It is very common that, on the other side, elderly esteemed persons, women from the community, perform this genital cutting. This may be either a woman that is skilled in and paid for executing this task, so-called professional cutter, or a female relative as well, which is one of the explanations for the very high number of unreported cases. In principle, both categories of women that perform the procedure have also undergone FGM and derived their experience and understanding from their own mutilation, as well as from cuttings they themselves performed in the meantime. So not only has FGM a twofold gender mark, as victim and as perpetrator, it regularly does the former victim transition into the new role of a perpetrator in the broader sense. So the former victim is the future perpetrator, and it goes on and on and on in this circle. This can be either in the role of the principal offender when the woman performs FGM, or in the role of an accomplice or co-offender who is inciting, coercing, and procuring. And this is the reason why this Article 38 of the Istanbul Convention is good, because it includes them as well. Yet, due to the absence of understanding FGM as a physical and psychological violence or as a transgression at all, the women who have experienced that very often do not know that this is something that is not to be done to them. There is no consciousness that they themselves are doing something blameworthy. And then again, talking about the issue of criminal law, because it should be an intentional conduct. If the person themselves have no consciousness that they are doing something that is a transgression, some may say that they did not act intentionally, at least in the regard of mutilating the girl or woman. What the problem here is that they are perpetuating the subjugation of the next generations of women together with the rest of the community. The difference is that they themselves have experienced it and maybe even conducted it. And yet, the community pressure and the desire for respect and reputation seal the unbiased view on FGM. For the mothers, it is important to prove that their daughter is respectable, moral, society conform, and because of this, a marriageable person. Marriageability, a very important notion. For the mothers-in-law, it is important that her son gets a decent woman that will contribute to the reputation of the new family. So again, reputation of the family and the loss of one individual in this particular practice. The Istanbul Convention therefore rightly identified various forms of contributions to the crime and integrated them, as I mentioned in Article 38, not relying on the foresight of national legislators. Furthermore, the Convention contains in Article 41 a separate provision on aiding or abetting an attempt with reference to Article 38A. So again, this means including other institutions of criminal law. By doing so, the Convention included and made a whole range of participants legally visible, which has also been done for the first time. What remained invisible, or rather blocked out in the picture that the community draws of this custom, aside from the very nature of the cutting, is the aspect of very tangible duress that an intervention has to be suffered through. The nature of the procedure is clandestine, so is the female body and female sexuality. Only afterwards comes the revelation and the harvesting of the promised advantages of having mutilated genitalia. So everybody knows that this has been done, nobody talks about it, but nonetheless it is a practice that still goes on and on. Traditional birth attendants, medical professionals, and even barbers and herbalists can also carry out the act, speaking about the actors, although this happens rarely. With an easy access to medical services, and this is a new issue here, according to some estimates, 1 in 5 girls was cut by a trained health practitioner, by a doctor in a hospital, but not always, which is a new term or a new trend in FGM called the medicalization of FGM. Irrespective of the motive on their side for such a medically, again, not indicated intervention, whether to provide a more secure procedure or to simply fulfill the social obligation which was asked for, they do not always do that for money. Without questioning it, the issue of the criminal liability of healthcare providers remains, next to the question of the disrespect of medical ethics while performing an unnecessary bodily mutilation. FGM remains harmful to girls and women even when it's carried out by physicians. Medicalization further reinforces the continuity of the practice by seemingly legitimizing it. This means that now we can hear a lot of, also in scientific works, a lot of arguments that say now that FGM is done in a sanitary condition by physicians who know what they do, this practice can at least be tolerated. They once again shut out of the focus the main issue with this, and this is the lack of medical indication. Gender-based violence is perpetuated by these circular social structures of power. If an individual is powerful because he or she is a guardian of the traditions, customs, and identity of the community, then the individual will want the practices to continue. Later on, the scheme of power is transferred to one's own offspring, and the circle goes on and on. Now, I took out some cases because although FGM, even as a particular crime, is criminalized in many of the European legislations, there are not many cases. So there's a high number of unreported cases due to the fact, as I've said before, that it's done or at least incited by a family member. This is one reason. And the second reason for that is that it's not done in the place of residence. For example, a lot of women and girls are subjugated to FGM, although they live in Western Europe. They are basically sent on family vacation, and then it's done there in the land of origin of their parents. Now, out of a modest number of court cases related to FGM, the following can be mentioned. In the case from 2008, there was a daughter of 2 Somalis, parents of 8 children, who were asylum seekers who have arrived in 1993 in Switzerland. The girl was cut at the age of 2 years, done for only 250 Swiss francs by a Somali physician in Switzerland. So again, there they would not go to an unknown doctor, but to a very, at least to them, well-known person of trust. They trust. The mother wanted the cutting. The father was against the complete removal of his daughter's external genitalia, asking for a less invasive intervention. So they agreed to remove only the clitoris. Both parents were convicted to a 2-year suspended sentence, but the sentence was suspended. Only 2 years, meaning that if 2-year suspended sentence means that if they, in a certain period of time, once again commit this or any other act and are unconvicted of it, they will go into jail. So the sentence is being revoked, or the suspended sentence is being revoked. And this would mean that they would go to imprisonment of only 2 years. However, if they do not commit again an criminal act, and very possibly is that they will not do it because this is a once in a lifetime thing they have done to their daughter, then nothing will happen. They will stay at liberty. And this is something that happens very, very often. In an interview, the father declared that at that time it felt normal for them to let their daughter to be cut. The reasons are usually for FGM are roughly categorized as psychosexual, sociological and cultural, hygienic and aesthetic, religious and socio-economic. Yet those arguments cannot be strictly divided into only one category. They overlap and goad each other. In basically all of the mentioned categories and arguments, gender-related misbeliefs and misconceptions are the foundation that paves the way for justification in the eyes of FGM practitioners and supporters. And now I will list you only a few of the reasons. Again, there is a whole list of possible justifications for this practice. It is seen as an initiation rite, coming of age ritual or passage rite. It marks the transition to womanhood. The sense of belonging is literally interwoven into the removal of external female genitalia. Some may call it building of an identity to divert from other cultural groups. The mutilation of girls at a very young age, or even as babies, is something that's clearly falling out of this argument, by the way, because the presumed easiness to bear and forget the pain, avoidance of dissent, if consent is required at all, and an early fitting and adapting to a future role remain the main motives for cutting of newborns, infants, and toddlers. This future role is connected to another alleged characteristic of FGM, the marriageability of a woman. Besides her being cut, she is also introduced to her expected responsibilities as a wife, later mother, and thus as an accepted, although still inferior compared to men, member of society. So we talk here about basically fixed gender roles. An uncircumcised woman cannot marry and is ostracized by her community, tribe, and family. Maintaining the virginity of the woman is a precondition for marriage. By her being mutilated, the sexual desire of the woman was curbed, her chastity maintained, and thus her and her family's honor preserved. Again, honor. The female body is being treated as an object for a higher collective cause that she, if she wants to be part of this community, has to subjugate to. Suppressing her sexuality functions also as a prevention for her to become unfaithful and ensuring the fatherhood of a husband, a very practical reason. The uncircumcised woman is altogether seen as an unfaithful, wild, untrustworthy subject that, in order to deserve the acceptance and the respect of the community, needs to let go of parts of her disruptive, raw femininity, some even call it masculinity, by the way, in order to gain a predefined, decent femininity, often synonymous with obedience and submissiveness, like all the generations of women before her. Her sex should be clearly identified. For this, it is necessary to remove the clitoris and the labia. They are called, by the way, the inverse male parts of her body, to purify her and to help her to become a complete woman, because not only is she filthy, driven by her libido, her external genitals could hurt the baby during delivery. This is very often heard. Are unsightly and dirty and need to be cleaned for additional hygienic and aesthetic reasons. The whole narrative is reflected in the respective names of the practice as well. So in Ethiopia, an uncircumcised woman is pejoratively called kintram, which means the one with clitoris. And in Guinea, the term for FGM can be translated into common help. In Egypt, the respective word tara means to clean or purity. Now, this is not something connected to criminal law as such, but I found it very interesting, namely the comments of the women who were defending FGM. And one Egyptian woman was quoting with the following statement: "We are circumcised and insist on circumcising our daughters so that there is no mixing between male and female. An uncircumcised woman is put to shame by her husband, who calls her you with a clitoris. People say she's like a man. Her organ would prick the man." And another comment from a woman from Sudan, also with a very high prevalence rate, over 90% there as well. "In some countries, they only cut out the clitoris, but here we do it properly. We scrape our girls clean. If it's properly done, nothing is left other than a scar. Everything has to be cut away." And the last, not the only, but the last of the arguments pro FGM for today are the economic motives, which also play a role, because one of the main driving forces, marriage, is actually not an option for a girl or woman, but a means for survival in times when economic security, social status, and respect of society are linked to marriage and reproduction. They come from very poor societies, where if they do not marry, they cannot economically survive. So this is basically this economic violence we talked about before. It's not obvious on first place, but it still exists. Now, female genital mutilation versus male circumcision. What they both have in common, male and female, is they represent an irreversible genital alteration. So this is the same for both. On the other hand, the consequences of female genital mutilation and its male counterpart are very different. Any consideration of female genital mutilation naturally encourages this discussion of the similarities to the male version of it. Infant male circumcision, like female circumcision, proceeds upon parental consent. So this is also more or less the same. There is precedent for parents to consent for medical treatment on behalf of their children. However, they are usually interventions with clear medical benefits. So one of the reasons why this is not the same is that on the one hand, the female genital mutilation has definitely, literally no medical benefit at all, only downsides, whereas the male circumcision has some clear medical benefits. It includes, it's done for hygienic reasons. It decreases the risk of HIV acquisition or other sexually transmitted infections, and in general other illnesses as well. Then the issue of complications. If a male was cut, there are no consequences, no short or long-term consequences to be expected, where on the other side, if it's done to a woman, I've listed you all the consequences that they are there. Male circumcision, this is a very significant point that I'm mentioning right now. Male circumcision is done for cultural or religious reasons, but female circumcision reflects an underlying message, and this is the point of it, about the status of women and an intention to affect their sexual function and behavior. If a man was circumcised, he can continue to have sexual intercourse. This is exactly what the woman cannot do after being mutilated. Importantly, male circumcision does not intend to affect the male's future sexual behavior or communicate a lower status of males. Combined with the minimal medical risk and potential of medical benefit, male circumcision has fewer consequences than FGM. So those are the reasons why this cannot be compared. But on the other side, there was a different point of view from a district court of Köln in 2012, and it was the case of a 4-year-old Muslim boy who was who was circumcised in a hospital because his parents wanted it to do so. And 2 days after the procedure, which was done by a physician, but which was again medically not indicated, he continued bleeding. And the court found out about that and started investigations. And there was a huge outcry in Germany on this because it came to the clash of two freedoms or two rights. On the one side, the freedom of worship, and on the other side, the well-being of the child. So in the end, what was done, there was a huge outcry not only from the Muslim population, but also from the Jewish population, because Jewish males have to be circumcised when they are, or on the 8th day after their birth. And this means that those males can in no case give in any combination their consent. So it's basically about the mutilation of babies. And what did the German legislator do? Because he didn't want any other clashes. There were really discussions about that in the German society. So what did he do? Although there was the criminal investigations on serious bodily harm, because the district court has rightly so regarded male circumcision as serious bodily harm. Again, alteration, irreversible, no medical indication, and later on with the secondary bleeding. The German legislator took the other way around through civil law and introduced a permission clause, which he introduced into the civil code. So now there is basically a justification ground in the civil code which allows, permits parents to give their permission or to circumcise their boys. And what's also interesting, they have altered it, so after the boy is 6 months old, it can be done only by a physician. So six if the baby is 6 months old or older, only done by a physician. But also paradoxically, if the baby is younger than 6 months, it does not necessarily have to be done by a physician. The reason for that is that in the Jewish religion, the circumcision is done by certain, I would say, priests, how to call them, definitely no physicians. So this is the reason why this clause was introduced. And now we're getting to the next points, and this is also our part where we start a discussion, or I would like to start a discussion with you. Although I have some points at the end, but I think this is more interesting, namely new offenses. We talked so far about the general part and the special part and the gender-related issues. Now, we have recently, I've named 3 of them, some new offenses, not necessarily in our legal system, but in the surrounding legal systems, which means that in a certain period of time, we will also have to deal with them. It's just as it is. Upskirting. Upskirting is the first thing that is regarded at some jurisdictions as a crime, and this is an informal term for a type of voyeurism when someone uses equipment like a camera or mobile phone to take photos or videos underneath a person's clothes without their permission. This is something that is already covered by other criminal offenses in our legal system, so it would not be not punishable. But however, it is now regarded as a specific criminal offense. And I would here at this point like to start a discussion either about those new offenses, I will mention 2 more, or about the things I've mentioned before. So please.
Okay, before the others, just a few things. So all the aims of this mutilation which you mentioned can be summed up, in my opinion, and you can comment that. We have already mentioned that during the previous lecture when speaking about female genital mutilation. Control over the body of the woman and reducing her to the reproductive function. All those honor and all other, compliments which were mentioned, all of that, as a matter of fact, serves to this, reducing the woman to limiting or annulling her feeling sexual pleasure, but only this. So, reducing the woman to the patriarchal, in the given context of the culture, but reducing to her patriarchal social role. That is one point, I think the most important one. Then you mentioned mothers who had been the victims and then have been becoming the perpetrators. That's again something what is called in the feminist theory internalization by women of the patriarchal social roles. So that woman, independently from the fact that she was the victim, she has been playing her patriarchal role and making her daughter or daughters also to fit into that. I was surprised that you did not speak about femicide and about the rape in the family, and more about rape, but if you have a time, please speak about that. But just before that, to mention, Professor Bojana Čučković spoke about our legal clinics, and she also mentioned the human trafficking legal clinic, and I was once there when the NGO who takes care about girls and young women and previous students in their countries, different countries, who have been in the process of asylum seeking on the basis of gender-based violence which they had experienced in their countries and their families. And one extremely intelligent and nice young woman, and I hope she will become the student here, and she is the asylum seeker from Nigeria. She spoke about her experiences of she was rather old when this genital mutilation was planned for her to be done by her mother and her neighbors, and she was enough old to be aware of and to have her autonomous opinion about, and she ran away from her family. But then she became the migrant and she became the victim of smuggling and human trafficking. And after a few years of who knows what kinds and amount of her suffering, she managed to survive, and then etc. etc. So these multiplied gender-based violence, who knows how many of them there are among those migrant kids, especially from those flows from 2015 and on.
Thank you for the comments. I fully confirm what you have said. I do think the same regarding the control of the female body. I mean, it's basically interwoven into the legal provisions I've mentioned, and also the reduction to the sole reproductive function of the woman. You mentioned sexual pleasure. Sexual pleasure is something that's either not mentioned at all, or something that is only a bystanding effect that has to be taken into account. So basically it's about not solely about the birth machine, because the woman, for example, when we talk about FGM, she's then, when she has to give birth, again cut open. But the point that before and after that she's not allowed, or there's no trust in her. Not only that she is allowed to have any kind of pleasure, it's like the basic distrust into her. She's
control in all respects.
She's per se unfaithful, and because of that she has to be mutilated in such a way. And this is something that at the same time, it's interesting that if a woman experiences FGM without the pain and with everything that goes with that she does not ask herself if this is the correct way. So in other words, the social context she has grown up in has put down all of her logical, instinctive reactions into pain, into bleeding, into possible death, etc., so on, which means that in this regard, Legal norms they can try to prevent this. They should definitely punish it, either through a specific norm as we have had it, or in Germany or in other countries, or through serious bodily harm, because in any way, this is a practice that is definitely covered by criminal law. It cannot be not prosecuted. But however, the point is to change the cultural, social attitude, the stance behind it, and also to open up those communities which live in a kind of parallel life to the majority communities in the respective Western countries. I know an example from Germany, because they really deal with it in a very systemic way. Since they have a great migration influx, also the number of women who are affected by or threatened by FGM has raised, with women and girls. And they have established, thanks to one certain woman, she's a physician, she's a reconstructive chirurg, and she has opened up a clinic only to help those kind of women to reconstruct their parts of the body which have been mutilated. So it goes into this direction. On the other side, also in Germany, the same in Serbia. In Serbia, it's understandable because we do not have those reports. We do not have it here. It exists as a crime in our criminal code, but it does not occur in practice. Whereas in Germany, it does occur in practice, but nonetheless, not even there are reports or even less convictions. So it's still clandestine. It still remained under the covers. This is regarding the second internalization of women. This happens very often.
Interiorization of patriarchy.
They have accepted the roles that were given to them, and not only accept it, they're living it and spreading it further to their daughters. And they're very often, as not only in this case they have mentioned, but also in other cases, they're very often more close to doing so than, for example, the fathers of the family. And this is also something that's interesting also in other similar crimes. When it comes to multiplied gender-based violence, yes, as I've mentioned before, when we saw the settings of the violence, it rarely remains only one form. It very often overlaps with the others. Marital rape as such, you mentioned it, is an issue that, to be honest, it's not an issue anymore insofar as it's recognized as rape. So it's not in that kind of problematic anymore. Also in the judicial practice, by the way. Regarding femicide, this was done on purpose because femicide reserves should be a topic for itself, because it's such a great issue. And we could speak for hours about that. But also regarding femicide, in our, for example, practice, as I've mentioned before, in general, when you speak about Serbia, the whole discussion on criminal policy is, I called it emotionalized, and it is. If you have a certain case, if it's in the newspapers, again, as we have this unfortunate case right now, very soon afterwards, the criminal code is amended. We have, on average, the criminal code amended every 2 years, which is quite frequent, maybe too frequent for such a basically static field of law as criminal law, material criminal law it is. But nonetheless, the criminal lawmaker reacts in average every 2 years to some events that have happened, and he doesn't even shy away from that. He says in his reasons why for the law, it was done because of this and this event, and we changed those legislations. So on the other side, when it comes to femicide, as I said before, there is no such outcry, nor will it be, at least until now, expected, to be honest. So right now we will see definitely a change in juvenile criminal law, that this will come. Very probably some changes when it comes to certain criminal offenses. Definitely the issue of firearms, of their regulation. But when it comes to femicide, no matter how many women have been, I think so far in Serbia until this year, 15 women have been murdered, will be an issue so far. As I said before, women or the murder women are not seen, not recognized as a particular group, subgroup that is to be protected by criminal law so far. So this is an issue that at least in Serbia will not be an issue. When it comes to other countries, criminal law dogmatics are not very, to be frank, not very happy with that concept, because this means that the universal value of life, no matter if it's male or female, if you're sick or full healthy, no matter what, is being relativized in this kind of in this regard. So it's not only about the criminal policy, but the mere systematization and the logic of criminal law is a bit suspicious about this issue. To be honest, again, we see it in the countries of Latin America. They go from one extreme to the other. I mentioned before about the Mary rapist laws, where they were still in effect. Now we have a different attitude towards femicide, because there we have some countries where we do have femicide as a specific criminal provision. So it obviously depends. Whereas on the other side, also I have to say, I'm not sure on how independently they can create the criminal policy also, to be honest. Another questions?
I would like to... Can I use this?
Sure.
I don't know if you can hear me, but I would like to maybe also have a comment regarding what Professor Dragica said and what you discussed, and thank you for your wonderful presentation. First of all, as Professor Dragica mentioned the case in Serbia, I can see one problem is that you said that she fled female genital mutilation because she was aware that it is a harmful practice. And Professor Krstić discussed about refugee law and how women can be protected based on the persecution when it comes to gender-based violence. And what I see as a problem is that I think that women very often are not even aware that they're victims of gender-based violence, and they can seek protection. And here we again refer to these social norms and not them being aware of the fact. Also, if you want to oppose to this practice, you can also be a refugee. You can become a refugee because you feel huge social pressure because you want to oppose to these practices, and then you have to flee a country. And another issue is that will it be recognized within European states? Because I think that we often expect from women in Europe to be aware of everything that the average European woman is, and not having this cultural sensitivization of our systems. Another issue that I would like to refer to, and I think that Professor Bojana Tručković mentioned this in her presentation about human trafficking, is that, okay, we have provisions in criminal code which are recognizing these practices, but maybe I'm not sure if, for example, in Serbia, our procedural aspects are in criminal offenses are following these material aspects of criminal law, because very often we see that even though women have special guarantees in our criminal procedures, they do not have, let's say, opportunity to use them in a manner that it will not victimize them during the procedure. Thank you.
Thank you, Anna. Are there any more questions?
No.
Mm-hmm. Regarding the secondary victimization in the criminal process, this is an issue that is long ongoing, but in our system, it's still, there are no specific provisions. And again, the only subgroup, let's say, that is particularly protected are again juveniles. So this is a social understanding that is incorporated in our society, that children, juveniles deserve a particular treatment better than the others, whereas women also from foreign women are not recognized or not identified as such. So not. I mean, there are currently. Now there's some strategy going on how to improve the status of victims in this regard, also in the criminal procedure, but so far there's nothing tangible. Yes, please.
Is this protection against juveniles applied in the situation where the where the victims are suing after they come out of the age. We have now a huge process with the Nikolić situation. So are they protected?
Juvenile
As it was committed when they were
underage. The propositions of juvenile criminal law, now again from the perspective of as a perpetrator, can go on until the perpetrator has reached 21 years of age. So now after 18, from 18 to 21, when they come of age, as far as I know, no, because they're now regarded as mature enough to deal with it. So no, and this is usually done for children who are like 15, 16, the lower end of the minor age.
So it doesn't matter when the act was committed. It matters how old are you in the process.
Yes, it matters when the act was committed regarding the classification of the act. Yes, but regarding your treatment later, but yes. But again, this goes out of my focus because it's more procedural law, so I would leave it more to my colleagues. So yeah. Another question. Should I finish this presentation? Just so the rest, it's not that much. So upskirting I've shown you. And koliko još 10 važi? Stealthing? Awesome. Važi, 8 minutes more. 8 minutes. This is a very interesting offense. It's a non-consensual condom removal before or during sexual intercourse. And this includes the purposefully damaging of the condom before or during intercourse, no matter if it's done by a woman or a man. So this is something that has gained momentum. And it's highly debated right now. It comes from the field of LGBT, but now has become popular also in other relations. So this is highly interesting. And the last one, revenge porn. The last one, revenge porn, the distribution of sexually explicit images or videos of individuals without their consent. There was a discussion last year and the year before that in our media about that, because various films and pictures occurred, but nonetheless this is also something that is covered by our criminal law provisions, of course not by a specific criminal provision as such. Now, the conclusion, when we look at the Istanbul Convention, what is a good thing is that there is a very broad range of criminalized behavior. I've mentioned the 8 very specific criminal offenses. Also, their formulations are broad enough to enable the national lawmaker to do the best out of it and to adjust it to the national systems. What is also laudable is that certain institutes of criminal law are included. I've mentioned unlawfulness, I've mentioned aiding and abetting, I've mentioned attempt. And in general, this means that the Istanbul Convention has set minimum standards in the area of criminal law. What international documents usually do, they focus only on certain criminal offenses and do nothing more. And then the national lawmaker makes the mistake, I dare to say, to take literally those formulations from the international document, which are very long, very precise, too precise, and incorporated into the national legal system, by this leaving out some aspects and then having a criminal offense that is written on one page, which practically does not come to life in judicial practice. In general, as I've said before, the gender orientation for criminal law is rather untypical. I've mentioned the places in the general and in the special part where it can play a role, but so far when we talk really about the dogmatics of criminal law, it's untypical. When we talk about criminal policy, it's another issue, but then again, we slide very easily into the issue, into criminology. As an outlook, I showed you those 2 pictures to show that the approach has to be balanced out. On the left side, you have graffiti where it's written catcalling is violence. So if you see a woman and you speak to her, etc., it is called catcalling, and some people regard it already as violence. Whereas on the other side, something that is definitely violence, serious bodily harm like FGM, is on the other side not everywhere regarded as violence. So we have a rather strange schizophrenic situation when it comes about that. So what we need is a balanced approach, And regarding the new offenses, we have to be aware not to overburden the criminal law provisions, because if we have too much of criminal law, then we have no criminal law, because in the end it's not about the number or the amount of criminal law, it's about the fact that the perpetrator can be sure of it, that if he commits a crime, that he will be prosecuted. So it's this that we have to enable. It's more about the area of police work, public prosecution work, and later criminal proceedings that have to be effective and functional, than to overburden, put everything into the criminal code, but it remains only written and not living up in the practice. Migrations, we talked about that before. It is an issue that means that issues like culture has to be taken more and more into account. Although we have national criminal laws, they cannot be formed only to one certain society, because even our society is changing. And this means that also the context of criminal provisions is changing. And in this regard, what's also broadening the scope of criminal law is the digital era we're living about. So everything will become cyber. We have cyber grooming, we have cyber stalking, we have cyber mobbing, everything is cybered. So this is something that we will have to take into consideration as well. Those were the topics for discussion, but I will not repeat that. I just wanted to say one more thing. Yes, regarding further reading. Who's interested, I can send you the presentation. And here in this further reading, you have two articles of mine. The one is the approach of Serbia to the substantial criminal law issues from the Istanbul Convention. So in other words, how did we implement the Istanbul Convention? Is it good? Is it bad? This article is not freely available. You have to pay some money, but if you want to have it, send me an email, I will send it to you. And the second reference is very well known, is from our book series Gender Perspectives in Law, the section on gender competent public law from Springer, which I can only highly recommend. So thank you very much for your attention.
And these others, feminist perspectives on criminal law, can we have it and upload?
I have dam. Hoću, mislim, I can. To je to. Thank you for your attention, and have a nice rest of the day. On time.
I want to ask a question.
Sure, ask.
Please.
Mike, please.
Because during break I mentioned about some cases that I said it was not rape, and then you said it's something like not pornography, you said something.
I mentioned revenge porn. It's not really revenge porn because there's no revenge. It's more like that they wanted to blackmail her into. In this case, you mentioned it was more about blackmail. So
use private recordings for.
Yes, because in your case you mentioned they had some private intimate recordings, and he blackmailed her to have the same with his friends in order not to publish it. So it's basically blackmailing. It's blackmailing. Yeah. You're welcome.